Hello, my name is Chris Rootham, and as I said in the first of these three presentations, I'm a lawyer with Nelligan Law in Ottawa. This is the second of three videos about collective bargaining 101, and this is about the duty to bargain in good faith. The duty to bargain in good faith is the cornerstone of the collective bargaining relationship, and it has two related elements. First, it has the duty to bargain in good faith itself. This is a subjective test. It's about whether the parties are actually acting in good faith. The second part of the test is objective. It requires both parties to make every reasonable effort to enter into a collective bargaining agreement. And these two duties put together, I've shorthanded into the duty to bargain in good faith. But when I'm talking about this duty, I'm talking about both parts, the subjective and the objective part of this duty. The duty to bargain in good faith is largely about the difference between hard bargaining and surface bargaining. Hard bargaining just involves pushing hard for what you want to achieve, saying no repeatedly, being very clear, I'm not moving off of this position. We are allowed to do that. Hard bargaining is permitted. Surface bargaining is not permitted. Surface bargaining is pushing hard for the purpose of avoiding entering into a collective agreement in the first place. So surface bargaining is not about the reasonableness of the proposals per se, but about whether the proposals are an indicator of an unwillingness to conclude any agreement. So surface bargaining would be saying no repeatedly to things that are obvious and have to be done, or saying no repeatedly without providing any kind of explanation. The duty to bargain in good faith permits us to bargain hard, but it does not permit us to go through the motions or to engage in surface bargaining. Bad faith bargaining complaints or an allegation of a breach of the duty to bargain in good faith, we can file those with the Labor Board, but there are some limits to what the Labor Board can do. It's not a way to remedy a lack of bargaining power. We are equal parties with the employer in this case, but some unions that are tiny, they just don't have the resources. They can't go to the Labor Board to fix that. They can't go to the Labor Board to level the playing field. More importantly for us, the remedies that a Labor Board can grant when there's been a breach of the duty to bargain in good faith are limited. Well, they can declare that there's been a breach of the duty to bargain in good faith. A bit of naming and shaming, but only naming and shaming. They can put us back to where we were when the bad faith behavior first started. So we file a complaint, 8 months later, the board decides that there's been bad faith bargaining. Congratulations, we now go back 8 months in time and start over again from where the bad faith behavior first started. It's not a terribly effective remedy. The real nuclear option for most bargaining agents when we're dealing with bad faith bargaining is an order that the employer and the bargaining agent have to go to interest arbitration. Well, except we can do this anyway. As soon as we've reached an impasse, we can decide to go to interest arbitration, which I'll describe in the third video. So this is why every time that we think that there might be bad faith bargaining, we're not in a hurry to run to the Labor Board. We're going to try to fix the problem first through further discussion and negotiation. Three specific aspects of the duty to bargain in good faith that I wanted to bring to your attention. The first is disclosure. Both sides have to disclose data. The data is things like basic compensation information and basic demographic information. Who's in the bargaining unit? How old are they? What's their length of service? What's their rank or what's their classification? How much do we earn? What are the cost of various benefit packages? What are the cost of our proposals? What are the cost of their proposals? Things like that. We also have to disclose future plans. So an employer has to disclose a plan that it has formulated pretty much up to the point of completion. They have to disclose that during the bargaining process. They can't ambush a bargaining unit and a bargaining agent the day or the week after a collective bargaining is done. So give an example that doesn't apply to us. Suppose GM decides they're going to close one of their plants, and they decide that during bargaining. They have to tell the union. They can't wait till there's a collective agreement done and then tell the union, oh, by the way, we're going to close one of our 5 plants. They have to tell the union in order to let the union bargain the plant closure, enhance severance, bumping rights, mitigate the decision to close the plant by opening a part of it and moving work around a bit. These are all things a union would want to bargain. And so an employer has to bargain these plans. They have to disclose the existence of these firm plans. The second thing that goes into the duty of bargaining in good faith is going backwards. Parties are not allowed to go backwards. They're not allowed to change their position. So to give an example, suppose an employer offers a 2% wage increase. The union, says, I want 5%. The employer is not allowed to say, I'm so offended by your 5% ask that I'm reducing my proposal to 1%. You can't do that. You can make a change in your position as a responding to some dramatic event. The plant's closed down, the employer's gone bankrupt, things like that. You can also change your position in response to some other proposal made by the other side. So for example, employer says, we'll offer 2, union says, I want 5, but I also want to double the overtime rate. We're getting 1.5 for overtime. I want 3 times for overtime. The employer is allowed to that point say, all right, 2% is off the table. We're going back to 1%, but I'm going to talk to you about the overtime. I'm willing to increase the overtime from time and a half to double time for certain kinds of overtime. So they're not really going backwards so much as moving the money around a little bit in response to the union's position. And vice versa. An employer makes a proposal, the union can do the same thing, go backwards, but move the money around a little bit. But otherwise, you're not allowed to go backwards just because you're offended by the other side's offer, just because you feel like it. That's bad faith bargaining. Third and finally, there is communication during bargaining. The parties must communicate with each other. They have to discuss their positions and they have to give reasons behind the proposals. It doesn't have to be a reason that convinces the other side. It doesn't even have to be a reason that convinces a neutral third party, but there has to be a reason behind each proposal. This goes to an important part of our duty to bargain in good faith, which means that we have to preserve the confidentiality of the bargaining process, because we cannot have the sort of candid, reasoned discussions with the employer and have the employer explain its proposals in detail while constantly going back to the membership to provide details of the each iota of discussion and the minutia of each discussion. This will not permit us to have the sort of candid discussion that goes along with our duty to bargain in good faith. You will know everything that is in a final agreement before you have to ratify it. So at the end of this process, if we reach an agreement, you're going to see the full agreement. You're going to know everything that we discussed. You're going to know what's not in the collective agreement as well before you're asked to vote to ratify yes or no. That's when you get the full disclosure from the bargaining team about what's in the collective agreement, but not before. You're going to hear from the bargaining team roughly when bargaining takes place. You're going to get some broad updates about, we've talked about some issues. We're generally satisfied with the discussion or we're not satisfied with the discussion, but you're not going to know the details until the end, because otherwise bargaining can't work. We can't have the sort of confidential discussion that we need in order to meet our duty to bargain in good faith and to allow the employer to meet its duty to bargain in good faith through this fulsome communication. I want to end this video by talking about something called the statutory freeze. The statutory freeze, it's a part of the duty to bargain in good faith. And what it is, it's a prohibition against changing terms and conditions of employment after either the application for certification has been filed or after notice to bargain has been filed. So we are in a statutory freeze period right now. What the statutory freeze means is that an employer cannot change terms and conditions of employment. But at the risk of abusing the metaphor, it is a soft freeze, not a hard freeze. And what I mean by this is the employer can still make some changes. So there's a two-part legal test. First, is this change actually about a term or condition of employment that can be included in a collective agreement? So is it a change about a term or condition of employment, or is it a change about something unrelated to the employment relationship? Is it something that's capable of being included in a collective agreement? Remember from last time, there are things that we cannot collectively bargain. So the statutory freeze only prevents those types of changes. The second and the more interesting or more important part of this is the change has to be something that's outside the reasonable expectations of members of the bargaining unit, i.e., is this consistent with business as before? So for example, if an employer makes a change every year on January 1st to a shift schedule, they're allowed to keep making a change to the shift schedule on January 1st because it's just following their business as before. That's part of the statutory freeze. Another example, has the employer announced something in advance prior to the onset of the statutory freeze? So has the employer said, we are changing our shift from 8 to 4 to 9 to 5? They make that announcement 2 months before the statutory freeze. They say, we're going to do this change. We're going to implement it January 1st. The statutory freeze starts on December 1st. They're still allowed to make that change because it's within the reasonable expectations of the members, because it's consistent with business as before. So it's not a hard freeze, but it is a freeze on most changes or terms and conditions of employment, and the NPF is vigilantly enforcing that statutory freeze, and we're filing complaints when we think that it breaches that statutory freeze. Finally, these rules are in place in order to permit us to engage in bargaining as opposed to just one-on-one, one-off negotiation. Collective bargaining, united we bargain, divided we beg. We have power in the aggregate through collective bargaining. And so this is where the message, if you're going to take away one message from this video, is that the outcome is going to be better than what happened before. The outcome is going to be better than each of you trying to individually negotiate your terms and conditions, because united we bargain and divided we beg. Thank you very much. This concludes the second collective bargaining video.